Everybody, welcome to LawPutra YouTube channel. The topic for today's discussion is grounds on which a plaint can be rejected. The court is vested with a duty that before a suit is established to appropriately inspect the plaint to decide regardless of whether it ought to be returned or dismissed and so as to decide the subject of dismissal. It is the court's obligation to take into consideration different materials as well. Order 7 Rule 11 of the Civil Procedure Code CPC 1908 describes situations where the plaintiff's plaint ought to be dismissed. It explains on the dismissal of plaints in specific circumstances and conditions. Grounds for rejection of plaint can be explained as follows. If a plaint does not disclose the cause of action, cause of action is a set of allegations and facts which make up for the ground of filing a civil suit in the court. For instance, the mention of cause of action is under Order 2 Rule 2 of the Code. Therein, it has been stated that for the purpose of instituting a suit, the cause of action needs to be explicitly mentioned in the plaint. If the plaint filed by the plaintiff does not specify a cause of action, the court will reject such a plaint by looking at the plaint. The court can reject the plaint on the basis only if it reaches to the conclusion that after all the allegations are set out, the plaintiff is not entitled to any relief. A plaint shall be rejected wholly. If the cause of action is not defined, it cannot be rejected partially. The Supreme Court in the case of Alka Gupta versus Narendra Kumar Gupta held on the fact that the cause of action in the preliminary suit was not compensating the cost under the sale agreement, though in the subsequent suit the reason for activity was non-settlement of records of the partnership that was dissolved. Next ground for rejection of a plaint is locus standi. The basis of filing of a suit is locus standi. The term means that one needs to show some legitimate right of the individual has been damaged and such infringement has brought damages to the individual. If there is no locus standi, then no suit can be brought as it provides grounds which are abused which leads to the institution of the suit. The locus standi relies on whether any grounds abused which brought about the dismissal of the plaint. In case of Prithi Singh and others versus Chandrabhan and another, a revision petition was filed by the defendant who was the petitioner against the order of the judge of the junior division. The offended party argued that the respondent had deluded the court by expressing an inappropriate fact. Accordingly, the application was expelled, wherein the Punjab and Haryana High Court expressed that there was no wrongdoing in the request passed by the judge. What is more, consequently, the candidates have no locus standi to document the case and hence the plaint was rejected. Next ground for rejection of the plaint is if the relief claimed in the plaint is undervalued. When the relief claimed in the plaint is undervalued and the valuation of the claim is not corrected or extended by the court, the plaint can be rejected. This means if it is brought to the knowledge of the court that the valuation of the suit is fabricated or baseless, the court can order the plaintiff to reevaluate the amount and may allow sufficient time for the correction. Subsequently, the plaint can be rejected if the plaintiff fails to abide by. For the purpose of rejecting a plaint on this ground, the evaluation involved should be objective in nature. As held in the case of Meenakshi Sundaram Chettiar versus Venkatachalam Chettiar, the evaluation was of the rent of the leasehold, and this evaluation is an objective evaluation. Similarly, in the case of Commercial Aviation and Travel Company and others versus Vimal Pannala, it was held by the Honorable Supreme Court that while evaluating the value of relief claim in the plaint, the court needs to resort to the materials, evidences present The respondent plaintiffs in paragraph 33 of the plaint had claimed relief estimating rupees 25 lakhs to 30 lakhs. This was disputed because there was not an accurate estimate. However, the court held that it was not unreasonable on the part of respondent plaintiff to do so. The appeal before the Supreme Court was dismissed and reasons were cited for the same. Next ground for dismissal of the plaint can be an insufficiently stamped paper or plaint. Sometimes the relief claimed by the plaintiff is written on paper insufficiently stamped, and the plaintiff, on failing to pay the court fees within the stipulated time or extended by the court, the plaint can be rejected. As per Order 7, Rule 11 C, a plaint is rejected by the court if it has been written on a paper which has not been duly stamped and authorized. Order under this rule for rejecting a plaint must only be given after the plaintiff has been given a reasonable time to amend the situation. It was held by the Calcutta High Court in the case of Midnapur Zamindari Corporation versus the Secretary of State that the court had required the plaintiff to supply amended plaint with duly stamped paper, which he failed to do so. It was held by the court that further the plaintiff will not be allowed to amend the plaint, and the plaintiff was directed to pay an extra amount of court fees. The plaint was thus rejected. Another ground for rejection of plaint is if the suit is barred by any law or statute. If the statements in the plaint show that the suit is barred by any law, the court will reject the plaint. As per Order 7, Rule 11D of the Code, a plaint shall be rejected if the suit is barred by limitation. If a suit is barred by law of limitation, the plaint of such a suit can be amended at the hearing. It is the duty of the court to see whether there is non-disclosure of the cause of action or the plaint is barred under any law. In the case of Bhagavendra Sharan Singh versus Ram Prasanna Singh, the cause of action had arisen when the plaintiff challenged the gift deed after a period of approximately 22 years after the date of execution of the same. The plaintiff, in this case, has challenged the gift deed with the allegation that the gift deed is a showy one, hence not binding. The Honorable Supreme Court, after hearing the matter, decided in the view of the facts of the case, held that the suit is unequivocally prohibited under the law of limitation and that the plaint needs to be rejected under Order 7, Rule 11 of the Civil Procedure Code. Other grounds of rejection may include if a plaint is signed by a person who is not authorized by the plaintiff and it is not corrected within the stipulated time, a plaint can be rejected. Also, if a plaint is not showing a clear right to sue and the plaint is vague, it can also be rejected on certain grounds. Thus, please subscribe the channel, like, share and comment below the video. Thank you.